Hey class, today we're going to continue our discussion of the basics of law and the American legal system by discussing the elements of a civil case. We'll start with the parties that are in virtually every civil case. We start with the plaintiff, the person who is claiming they were harmed or injured or wronged. They're called the plaintiff. This could be an individual, a person, or it could be a corporation. It could be virtually any person, whether it's a juridical person, a corporation, an association, any kind of entity that is claiming to be harmed. They are claiming that somebody harmed them, a defendant, somebody who's defending themselves against these charges. That also could be a person, a corporation, whatever. So a party to the case is either a plaintiff or a defendant. You could have multiple plaintiffs. You can have multiple defendants. They are coming to the courts for a disposition of this conflict between them. Now, there's two major kinds of civil cases. In American jurisprudence, there's a legal claim, a lawsuit, a suit of law, which is generally asking for some sort of award of damages to make somebody whole or to put them back into a position that they were prior to the accident or injury, or to punish the person that wronged them, generally through a payment of money. Now, this is separate and distinct from criminal law, which we're going to talk about later in the semester. Criminal law is a different animal. We're strictly talking about civil cases. An equitable claim is the second kind of lawsuit that can be filed. It's a suit in equity is what they used to call it. This is about not so much a monetary payment, but some sort of equitable arrangement to do what's right, to do what's fair, I should say, not right. Right is a moral argument. Fair is a more accurate description, generally resulting in non-monetary relief. For example, an injunction, a judge's order for somebody to stop doing something. And whether that's the barking dog at 3 a.m. or an order of protection against a ex-spouse or an estranged boyfriend or girlfriend, it's going to be a non-monetary award. Now, you can combine a legal remedy and a equitable remedy in the same lawsuit. In a single lawsuit, you can plead for the court to award both monetary compensation as well as some sort of equitable result. So this legal versus equitable claim is one that's important to remember, which brings us to the burden of proof. How do you prove a lawsuit or a equitable claim? Well, the plaintiff has to prove to the fact finder, whether a jury or in a case of a bench trial, the judge, that their claims support the level of proof required in a civil case. In a civil case, and for our purposes, I mean, it's a little bit more technical, but for our purposes in this survey law class, the burden of proof for a civil case is the preponderance of the evidence, which is the idea that the plaintiff must show that it was more likely than not that the defendant caused the harm in the case. If you have to look at this monetarily, or excuse me, as a percentage, it would be more likely than not is the majority of evidence, 51%. I mean, the burden of proof is how much evidence goes to show, or that the jury must assess favors the plaintiff. So there's different burdens of proof for different kinds of cases. For our purposes, preponderance of the evidence is the standard for most civil cases. The elements of a civil case continue with the idea of jurisdiction. Jurisdiction is a fancy way of saying what court is the appropriate court to hear whatever kind of case that the plaintiff is complaining about. So we have a number of kinds of jurisdiction. We've already seen one kind of jurisdiction, original versus appellate jurisdiction. That's original jurisdiction is the trial court level, and appellate jurisdiction is appeals made from a trial court. But there's a couple other kinds of jurisdiction as well. For example, is this a case that must be heard by a national court at the federal level, at the U.S. trial courts, the U.S. Court of Appeals? Or is this a case that can be heard by a state court? Or does it have concurrent jurisdiction where either a state or a national court can consider the matter? That generally turns on what kind of law is being alleged to have been violated, or the burden, so for example, if somebody gets in a car accident, these are state laws that govern. The Illinois Motor Vehicle Code, for example, governs operating a motor vehicle on Illinois streets. And so you are alleging in your lawsuit over a car accident that this person violated the duty of care in operating a motor vehicle pursuant to Illinois Vehicle Code section X paragraph Y. That would be a state court matter. Now, if that matter involves a resident of Illinois smacking into a resident of Wyoming, then you might be able to argue that there's concurrent jurisdiction, or actually some sort of jurisdiction, because you have diversity between the two parties. If the amount exceeds $75,000 that is claimed, then you could argue that that case should be removed to federal court. We'll talk about this more in class. Jurisdiction, the exclusive versus concurrent, is relatively straightforward. There's some twists and turns that we'll expand on. Subject matter jurisdiction is another kind of jurisdiction. Certain kinds of cases must go to the national courts. Federal questions. Is this a federal law that is being considered, or diversity? What we just talked about, a case between citizens of two different states, for example, can result in it being removed. Now, there has to be a case or controversy at hand. This is a constitutional requirement. This is written into the U.S. Constitution. A case can proceed only when the plaintiff can show that they were actually harmed, that the harm was fairly traceable to the defendant's action or omission, and that it can actually be fixed by the courts, that the remedy can actually be something that the courts can do. For example, a person can't file a lawsuit and say, hey, we want to know what would happen if we had done this, and then get an advisory opinion from the courts. The courts are not allowed to give advice to say, well, if that happens, then this is how we'd rule. That's not allowed. There has to be an actual case before the courts. The case also must be ripe. You can't say, hey, this person's about to do this, and then preemptively sue them. The action has to have already happened. The defendant must have already allegedly acted before the plaintiff can file a lawsuit, thus ripeness. And a remedy from the courts. So we're talking about, for example, you can't ask the court to bring back somebody from the dead. Okay, that's not a remedy that the court can carry out. Standing is another idea. It's whether or not the plaintiff's participation in the case is appropriate in that case. You've got to show that the plaintiff has something to lose in the case. For example, in Illinois, there was a school prayer law that was passed 2010, 2011, something like that, that required public schools to hold a daily prayer in class, in public school. Well, the initial case was thrown out because the father of some students filed the case. And the courts threw it out because they said, look, you don't have standing. You're not a student at this high school. You're a parent, but you don't have sufficient nexus, a sufficient connection to the case, to the facts, to show that you've been harmed, that you, the adult, have been harmed. Now, what happened is the case got thrown out, and the students then filed a lawsuit, and that got acted upon in the courts, and the school prayer law got struck down as unconstitutional. So you have to show an injury in fact, that you've actually, your interests have been harmed somehow, that there's some causation, some connection between what the defendant did and your your alleged harm, and that it can be redressed, that it can be fixed by the court. Finally, venue. This is an idea about the appropriateness of the geographic location of the trial. Usually, it's the location of an accident. The physical location of the accident becomes the court, which takes the case. So if you get an accident in Elmhurst, you're going to be going to the courts in DuPage County. If your accident's in Chicago, you're going to be going to the courts in Cook County. And if the accident's up here in Libertyville, you're going to be going to the court in Lake County. So location of the accident, location of a contract execution, that this is where a alleged voidable contract or voided contract was entered into, that might be the location. The county where the principal defendant lives could be the location of the venue. Usually it's wherever the plaintiff files the lawsuit is the venue of the case, unless the defendant files a motion to change venue, to transfer venue from one place to another. Why does this matter? Who cares? It's court. Just go to court. Well, the concern is making sure that you're getting a fair judicial process, a fair shake for both parties. There are certain jurisdictions across the country that are notoriously generous juries. The difference, and there's all sorts of studies that go into this, the difference in a jury award, for example, from Northwest Indiana to Cook County is massive, millions of dollars for the same set of facts or similar sets of facts. Likewise, there's a downstate place called Madison County near St. Louis that is a notorious plaintiff's venue. This image here on the page shows one right outside Las Vegas versus Santa Fe, New Mexico. It's the same kind of thing. You want to make sure that people are being treated fairly. Usually it's an urban setting versus a rural setting, where the rural area is a little bit more conservative. They don't give out as much money. The juries tend not to award as much money. And this ties into jurisdiction. This is why, for example, diversity jurisdiction exists. You want to make sure that residents of two different states are going to, or can remove the case to federal court, for example, to make sure that they're going to be treated fairly, because they're going before a more impartial judge. A state judge, the argument goes, would not be as fair to a out-of-state resident as would a national judge who doesn't have any ties to either state. So goes the argument. We'll talk more about this stuff in class. Thank you very much.